another IPR or PGR. And from what I can tell, the way the Federal Circuit's looking at it, no, because you didn't have a chance to raise those issues. I mean, there seems to be a little bit of a fairness or equity. So I think that the scope of the estoppel will be more narrow than what people are worried about right now. And people will file, if there's enough money, people are going to file the IPR anyway and just find out how it is. But it is going to be a problem for the PTAB because you're going to have other people filing, and the PTAB does not like redundant grounds. They don't, you know, they want it, so that they don't want you to duplicate other grounds, other 103 type rejections. So they're going to be the first people handling it.
Actually, just a slight modification to that, because redundant grounds is not really a reason to not institute.
Right.
And, you know, one thing we see is when there are several different pieces of prior art is that, you know, one reason why we'll have multiple petitions from the same party on the same patent is because there are several different grounds. And, you know, one thing is that, you know, it's no longer a page limit, but there still is a word limit. And so you do have a limit as to what can go into your petition. And it really is the petitioner's responsibility to make their case, so to speak. And so sometimes if there are a lot of claims or there's a lot of prior art, you really do have to separate these into different petitions in order to really be able to show a reasonable likelihood that you'll succeed. And so this is at least my personal perspective. I'm not speaking for the board. I do not look at several petitions as necessarily being redundant. Each petition is going to be looked at and it's going to be reviewed on its merits. So even if there are several petitions on the same patent, and even if the prior art overlaps, maybe there are different you know, categories of claims, maybe there are differences in the claims, as long as each petition is making its case and making its well, at least I personally don't believe that there's really an issue with filing several different petitions.
So before we move to talking about some of the substantive changes in patent law that have affected prosecution, are there any key changes in terms of PTO review at the AIA proceedings that you think we really ought to highlight that we haven't had a chance to talk about yet?
It's working. Few things are in flux, but in general, it's working. It's working well, and the fact that the PTO has so many customers means it's, you know, probably doing what it's supposed to do. So I think we hit the highlights.
Great. So let's turn to some of these changes in substantive patent law and start with the big one of patentable subject matter. So the Supreme Court just denied review of a bunch of patentable subject matter petitions. So it looks like Mayo-Alice framework is going to continue to be our framework for a while. So Kathy, can you describe how this kind of increased importance of patentable subject matter has affected Stanford's approach to what it chooses to patent in the first place, or how it files those patents?
I think we've taken a big pause on diagnostics, product of nature kinds of things. A lot of our researchers do discover a phenomena that, you know, that you can measure something in the blood and it indicates something. And so we've ended up thinking those kinds of claims aren't going to fly anymore. We are a little bit more hopeful lately because there's some guidance out there on how to craft those claims. And so, again, we look to the practitioner, the patent attorney that we hire, to be able to craft them according to the new guidelines. But we were pretty discouraged before. I would say with Alice, we never filed a lot of software patents. I find that they're very expensive and sort of hard to interpret, but then there are also startup companies who would like us to file. So now, I mean, the practitioner is much more careful about having a machine transformation. But we do find that we're not sure how valid the existing patents are, both in diagnostics and software business. We didn't file business method patents very often, so I don't think that particular area worries us much. So I think it is in the biotech area that we're worried about, and we actually have the most success in licensing in the biotech area. So the whole industry is a little bit in flux. So I think it's just something that will be worked out over time.
I think that many commentators have been concerned about new doctrine is playing out, particularly in the biotech area. I saw a study just this week suggesting that the percentage of office actions with patentable subject matter rejections in personalized medicine patents jumped from around 15% in the years leading up to Mayo to over 85% since then. So do you think that this is going to, I know, Terry, you're involved in biosciences work. Are you concerned about this?
Yes. I think that 101 shouldn't be an impediment to, the impediment, it's a very high hurdle. I mean, you know, a few of us in this room are a little bit more senior than some of the students in this room, and 101 wasn't intended to be such a high hurdle because we wanted robust innovation here in the robust patentability. I mean, you know, patent terms are limited. It's not like trademarks or copyrights that get a lot more time. It's a very defined term, and it's a quid pro quo. You disclose your invention, and then others can benefit. And the future, in terms of healthcare, the future, I mean, we need diagnostic tests as much as we need cures. I mean, there's no diagnostic test for Alzheimer's. I mean, it would be, I mean, they cut your brain in an autopsy. That's the only way you know if someone had Alzheimer's. I mean, that's pretty bad. You should be able, if someone has dementia, you don't know quite if they have Alzheimer's or not, or if it's another form of dementia. So we need these diagnostic tests desperately. And I think that innovation, you're seeing less research and less money being spent on it. And I think that's unfortunate. And personalized medicine, I'm actually a pharmacist, that's my technical degree. I mean, I think most medicine is barbaric, the way we, you know, and most medicine, we probably, if we all needed an antibiotic, we'd all get the same dose of the same drug at the same time. I mean, that's not what we want. We want to know, for me, for my DNA, for my body, you know, what dose is best for me, which drug is best for me, what's going to give me the least side effects, what's the shortest you know, period of therapy for me. It's not a one-size-fits-all. And the only way we're going to get to that personalized medicine for each one of us is to actually encourage innovation. And how do you encourage innovation? It costs, there's something called the Foundation for NIH, and they're doing work right now on women with breast cancer. And they're looking at their DNA, their genome, and they're trying to figure out which type of medications are the best for which women for treatment with breast cancer. And they've got this huge study, I mean, it's hundreds of thousands of women. And it's actually fascinating, so that when doctors actually, if you have a certain type of breast cancer, they'd actually try and figure out what's your DNA, what are you more predisposed to, what's going to be the best therapy for you. And Foundation for NIH is doing it with support with a variety of pharmaceutical companies. They're supporting this research, but it's in one narrow area. We have so many disease states and conditions that if we can actually encourage innovation, you know, diabetes is a huge condition. We're all different, even with something like that. What's the best way to prevent it? Of course, we need diagnostic tests for that to figure out who's predisposed to the problem. So I like to see robust patent coverage because I think you get more robust innovation.
One of the areas that I think is really interesting is gene signatures. You know, we went through the marker phase and a target kind of thing, but gene signatures is interesting. And so is it 7 genes that'll indicate you'll have a predisposition for such and such disease, or is it 9 genes? And again, to find the proper patentable scope is really awkward. And then, is this going to be a product of nature, because this really is just
None of what I talked about, none of what she's talking about is patentable right now. Sorry.
So, Kathy, do you have any sense of how this is affecting the biosciences industry? I mean, I know you have a just particular window onto the system.
My view right now, even though everybody is acutely aware of it, it seems that they're still taking the leap, because we're having pretty good luck with licensing biotech inventions. Again, we're trying the best to file patent applications that are going to meet the requirements of the patent office, patentability, et cetera, 101. And I think everybody, as I said, they're taking licenses to patents that are pending, and we're hoping that over time it'll be a little clearer and that it'll fall out in a good way.
However, the Supreme Court did not consider Ariosa.
Yes.
And that's a pretty big Are most of you familiar with the Ariosa case? So you've got things like, you've got chorionic villi sampling, or what is it people get? Amniocentesis with babies to look at their genome, and it's good for the health of the baby as well as the mother. Well, Ariosa, it was magical what their invention was. I mean, now you just draw blood from a pregnant woman and pull the DNA, and you can tell if the baby's going to have any problems or not, and you can actually intervene in the pregnancy if you need to do so. Just by drawing blood, you don't need something invasive like taking a giant needle and putting it all the way through a woman's belly. I mean, that's, once again, barbaric in my mind. And what Ariosa did was magical. We all need it. I mean, if you're not familiar with it, your daughter and daughter-in-law will eventually use that technology, hopefully. But we're not encouraging that kind of innovation right now because it's a product of nature you're looking for. It's in nature. And you go, yes, but it's in my nature and it's wrong and it shouldn't have been there and I'd like some intervention. I'd like it to be fixed. And they go, well, still, it's nature. It's not patentable. So the fact that the U.S. Supreme Court did not reconsider that Ariosa case, and they got how many amicus briefs? A lot, from every major organization, and those amicus briefs are just brilliant. I mean, they're so articulate, eloquent, poignant. I mean, it's like, how can you not accept certiorari on Ariosa? They didn't accept it. So someday we'll find out how that vote went.
So we are very discouraged with the Supreme Court rulings in general.
Kathy, does Stanford make any attempt to help professors outside of the patent process with commercialization? I know that you're mostly involved in patenting and licensing, but many professors are going to be doing their research even if they can't get patents on it because they want to get
So
tenure
I
and
often say that we have the luxury of being in Silicon Valley, and our students and our faculty and researchers are very entrepreneurial. So as an institution, we don't officially do much to help startups, but there are so many people who've been involved in startups who know how to do it, and connections are far extensive. And so, again, we're in a very unusual position compared to most other universities or regions in the world.
So they'll do research no matter what, which is good.
When the PTO solicited input last December on kind of specific patent quality issues, the top vote getter there as an issue that they should focus on was the perception of examiner inconsistencies in determining patentable subject matter. So do you all agree that this is kind of the biggest patent quality issue right now that the PTO should work on, or are there other patent laws that
Of course, we would like to see patents issue faster, and we want some, more assurance that the quality is good, and that the examination is good. I would say we still feel that they're pending way too long, and so until you get an office action to see where we are, and then hopefully it issues or not issues. I mean, if it isn't going to issue, that's fine, we know, but this pendency is pretty long. So we still feel like it's 5 or 6 years in biotech for sure.
So she thinks it takes too long for most of them in general. But in biotech in particular, it does take a while. The consistency issue, it's human nature, so I guess, yeah, there are some differences. But in the PTO, there are some outliers. But now that you've got these third-party services, where you can get the metrics and the information on a particular examiner, the number of times the examiner requires the applicant to go to appeal, the number of times the examiner pulls it back from appeal by issuing a new office action, the reversal rate of that examiner on appeal. Just as society gets more transparent, the big data issue, the big data in the patent office will, and the patent office has it, and they've got, if you work in group 1610, you all get similar cases, similar subject matter, so you should have a similar rate of appeal of your cases and a similar allowance rate because the cases are similar. But if you look at there's always outliers, but I think the patent office is looking at the outlier type issue and trying to pull in more consistency, and I think that's what Wallace is working on right now with the quality initiative. And I think they're aware of it, and I think they're trying. But there is a union also, so they can only do so much and move so fast.
So another doctrine that's seen recent changes is indefiniteness, where we've moved potentially in the direction of making it easier to invalidate patents for indefiniteness, including reading more claims as means plus function claims that are invalid because there's no corresponding structure in the specification. So one might expect this would have patent prosecutors being more careful about writing definite claims in the first place. Do any of you think there's been any change in patent prosecution and claim drafting in response to this?
On that, I wouldn't
No.
have much to say.
No, I don't think things changed dramatically with the 112 decisions we've gotten either from the Federal Circuit or the Supreme Court. Means plus function claims have always been a little bit of a problem, but I don't do a whole lot of those in my world. But from what things have not changed dramatically in terms of 112.
Yeah, and from the perspective of the PTAB, there's always going to be this sort of built-in time delay before we start seeing patents that have actually issued. 112 also can only be raised in PGRs or CBMs. But one kind of interesting area with 112s for IPRs that we've been seeing is that there'll be a prior art challenge, and the petitioner cannot raise a 112 challenge, but what will happen is we might look at the claims that are being challenged, and we might recognize a 112 issue. And because we can't determine the scope of the claim, we cannot determine whether or not the petitioner has shown a reasonable likelihood that the prior art is within the scope of that. And so what you're starting to see now is that in certain cases, institution will actually be denied, and the reason is because the claim has a 112 issue, but that determination that the claim has a 112 issue is it's not binding on any other court. It's just that's our determination. That's why we're not instituting, and so it raises an interesting dynamic.
So I was hoping we have about 20 minutes left, and soon I'm going to be taking questions. I hope you'll all be thinking about your questions so I don't have to cold call all my students. But I wanted to, before we turn to questions, see if we could kind of step back and think about things from a more global perspective. Chief Judge Rushke was talking about the EPO proceedings and how they're different from the PTAB. Terry, I know you have significant international IP experience, and Kathy, I know Stanford makes a lot of patent filings overseas. So have there been changes in other patent offices that mirror any of the changes in US law or aspects of other patent practice in other countries that you wish the US would adopt?
We don't file as much outside of the U.S. because of the expenses. Again, all universities are sort of constrained on expenses. We spend $10 million a year anyway, mostly on U.S. filings. And again, we expect an exclusive licensee to reimburse us about filings. Filing expenses just the most expensive part of the business, I guess. We're trying to figure out how much we should file in China, for example. That's a country that we feel like we can't ignore, but we're not certain how their patent law is coming into play, and it's maturing. So again, thinking about our early stage inventions at some point that will probably be useful, throughout the world. And so should we invest now in a sort of an uncertain patent situation to hopefully get patent coverage later in China? I don't know what's going to be happening with the European patent system or European patent. Now, I think that would have been a good thing. We would have been happy with that, and I'm guessing it'll still go on somehow. But Brexit is throwing a wrench into that. We will still file in the countries that we consider easy to file in are Canada and Australia. So we will always do those if we're going to do foreign. We do the PCT a lot, and then actually often that's a decision point whether to go into the national phase or not, because that's obviously the expensive part. So many times we'll cut off prosecution foreigns. It gives us some time to measure the market's response to the invention, and so we'll often make an important filing decision then.
So other countries are a little bit more flexible in terms of our 101 problem. Ironically, I mean, it used to be the U.S. found more things patentable and outside the U.S. less things patentable. Now, in the life sciences, they seem to be encouraging their own innovation. So sometimes in life sciences, you can get a broader claim scope, or you can get a claim out of Europe, Japan, China, that you couldn't get out of the U.S. In terms of the EPO and their opposition practice, theirs is much cheaper than the PTAB, but you get what you pay for, and it takes forever at the PTAB. And then they have an appeal after they're, so you've got, if you have an opposition in Europe, could take easily 5-6 years, and then you got an appeal that could take 3-4 years. I mean, in terms of, yeah. Most clients don't have the patience for that. So the European oppositions are, it's not something that even now that I like. One thing you can do during European oppositions, though, is amend claims. And you could actually amend claims and have auxiliary sets and subsets of claims. I think I'd like to amend my claims this way. I think they're patentable. And if those aren't, here's another set of claims, and these might be patentable, and then these might be patentable. I like that auxiliary claim set and that opportunity to amend claims that Europe has, but that would, in the opposition practice, but that's probably the only thing I can think of that I like, because it takes just too long. And even though it takes too long, you get all your surprises right before the oral hearing or right before something's due, and then you don't have sufficient time really to rebut it and handle it.
Do PTAB judges get any opportunity to interact with foreign counterparts or to see what they're doing?
I personally have not. I would probably leave to Chief Judge David Rushke or Michelle Lee, the director, as to how much interaction there is with our foreign counterparts.
I do know that people from other patent offices frequently do go to the PTO and meet with now Chief Judge Rushke and Michelle Lee and others. And I think that the Chinese Patent Office just sent somebody, I believe, last week to the PTO, and they wanted to find out how things were going, and they wanted to learn, because we have the IP5, the 5 biggest patent offices in the world, where like 80% of the filings are, US, Europe, Japan, Korea, and China. And so there's a lot of communication and, believe it or not, collaboration between those 5 big patent offices. And so everybody, we all think we're the best, right? But you still want to learn from each other, and everybody's still trying to improve what they do. So China was just there recently, and they were just in Alexandria, so they probably talked to a number of judges in a number of technology areas. And I don't know if they've actually ever, what patent examiners do from other patent offices in other countries, you'll have someone come over from Japan for a month, or we'll send somebody to China and work with them on how we identify patentable subject matter and prosecute pharmaceutical patents, for instance. I haven't ever heard of that with judges, because no one seems to have any spare judges, but you never know. And maybe eventually, not only the unitary patent in Europe, maybe we'll have in a couple more lifetimes a world patent, in which case you'll have judges from different countries be on the panel. So it's like, yeah.
Lisa, one of the things that I really have liked in the past few years is that the PTO sends examiners around to the outside to try to educate them as to what's going on. And so they've sent examiners from different units to Stanford and to our office, and they really get to understand the ramifications of their decisions.
The examiners like it too, so they go visit individual corporations or universities that will host them, and they spend a few days there, and they just try and understand what's going on, what their business is, to give them, the examiners, a framework for their decisions. And the examiners love it too. Trouble is, it's really expensive. And if the PTO budget can handle it, they do it. So they'd rather put people on a bus and send them to Maryland than to put them on a flight and come out to California. And this is where most of the action is. So the examiners who get to come out here are always thrilled.
Great, so let's open it up to some questions from all of you. I think we have a microphone that bring over here. If you can introduce yourselves, that'd be great.
My name is Fred Hadidi. I'm a practitioner in Menlo Park. I have a question for Judge Zotto. Are there common tactical mistakes you see in IPR briefs? For instance, do parties spend too many pages discussing some issues and not enough pages discussing other issues?
So in general, every petition's different. The pages are your own. Some of the things that are starting to phase out, spending time talking about, for example, redundant grounds. As I said earlier, redundancy is not a reason to institute or not institute. I've seen it both ways, parties saying the grounds are redundant, another party saying they're not redundant. That I have not seen influence judicial decisions. Another is for claim construction. It's really tricky. I've seen parties, because there's a concurrent district court litigation, they will construe every single claim term that they're construing in district court, even though for purposes of our decision, maybe only 2 of those terms really are relevant. And so one thing to think about is just, not having this impetus to try to get to put all of those claim constructions before us if, you're spending a lot of pages on it. Aside from those 2, I would say that there aren't really hard and fast rules. It's just about, as I mentioned earlier, one of the things you have to think about is if, as the petitioner, you have to show, at least at the DI stage, the institution stage, a reasonable likelihood. One of the things I see, though, is as a petitioner, you don't want to shortchange yourself. If you have a 103 argument, sometimes, what we see, because there are just so many grounds, is it starts getting really short and thin on the reasons to combine or the rationale or why a person of ordinary skill would have done this or why it would have been obvious. And then also with dependent claims, because I know some panels sometimes will institute based on one claim, and then they'll go ahead and say, we're going to go and institute on all the other challenge claims, but not every panel does that. Some panels go on a claim-by-claim basis, and so for some of the dependent claims, if the arguments really aren't well articulated, you will see that we institute on some of the claims, but we don't institute on the dependent claims. So as a petitioner, just be mindful of that, because you don't know who your panel's going to be, that you don't want to shortchange yourself on any of your claims or any of your arguments. But other than that, I mean, just at a high level, that's all I can think of.
We have a question over here.
Hi, my name is Adam Ullman. I'm an inventor, entrepreneur, and I have an LLM in intellectual property, commerce, and technology. This question is for Terry. Terry, when you were with the PTO, I'm curious how the setup of the AIA and PTAB it really seems to challenge the validity of a patent and why there wasn't further consideration to take a look at helping enforce patent rights through a system, a less expensive system than full-blown patent litigation, such as something that's done in Germany where they don't have discovery. And it seems like the setup right now is to invalidate a right rather than to help enforce a right.
So the PTO did what Congress asked it to do. And what they asked the PTO to do is reconsider granted or issued patents in view of new or the same information. And so that's what we were asked to do. I think that if somebody's patent survives one of these challenges, survives an IPR, PGR, or CBM, you very well might have a gold-plated patent, right? If the best arguments were used against that patent in an IPR, and the PTAB said, all the claims look fine, we're not invalidating any of them, if you're involved in a concurrent district court litigation, you're going to run to the judge and say, look they have a higher standard than you have, judge, here in district court, right? I mean, they just needed a preponderance of the evidence, and they couldn't even show, they couldn't meet any of their burden. So I think that maybe it indirectly assisting enforcement is an indirect benefit, but what the PTO did was what Congress asked it to do in the statute.
Do we have another question? Katie over in the front. Good microphone over here.
Does she get extra credit?
So I'm Katie Mladenich, and I'm a student here. And so I guess I had 2 questions, but I can just ask one if other people have questions. In the very beginning, we were talking about how the grace period can help, and if that was a little bit more clear, that could help, like Stanford. And I was wondering if changes could be made, or if that change was made, if that would actually, it would benefit the technology licensing office at Stanford and maybe other universities, but if that would also inadvertently help the more disreputable NPEs, and if there was a way, if you could see like legislation being passed that could help like the legit NPEs who are like not out to like destroy the world, but then at the same time make it so that the evil NPEs aren't benefiting, if there was a way to like separate out that.
Well, during the period where AI was being debated, all universities don't speak with one voice is one of the problems. And there's a sector of universities who really, really, really liked the old system completely as it is, didn't want it changed at all. We had the grace period. There are others, and including myself, I was fine with first to file because the rest of the world is first to file, and usually we had to make the decision anyway. And so I thought we came up with this in-between thing that was a little awkward. If we have the grace period again, it will be better for us because our faculty and researchers rush to publish, and often they'll call us the day before and say, oh, I forgot. I mean, totally, inventors who disclose to us all the time still disclose to us at the last minute, forgetting us until the last minute. So the other thing is the definition of publication or what they've talked about. And so again, universities are very open. We talk a lot. They have seminars, et cetera, et cetera. So again, sometimes that whole publication area is dicey for us. If we had an exception that, for instance, universities could have this grace period, I think that would be good, but there are other people in other universities who say, we don't want to make ourselves special. And I understand that too. We don't want to have industry-specific laws, basically. So again, I think it's actually a fairly complex debate.
Yeah, and speaking not as Judge Zotto again, another way to look at this isn't just the grace period, but one of the things that was put into the AIA was an expanded prior use right. And in Europe, there's, they're first to file. And what they have is more robust than what's currently in the US law. And the prior use idea is not that it will make a patent unpatentable, but if you are a company, for example, and you've been practicing the patent for some time, or the patented technology, it could serve as a defense to infringement. And that's something that also tempers a little bit this notion of a grace period, because if somebody else, let's say, for example, the grace period were to, the scope of what it covers is broadened, and there's this concern, as you had mentioned, maybe about some actors who are not necessarily, some people may not think that those are good actors, but something that helps temper that a little bit is also the idea of having more robust prior user rights, so that at least those who are accused of infringement would have a defense that they even though it's based on dates, it's still a defense that would help sort of temper that effect.
And I'll just add, again, the universities don't speak with one voice. With prior users' rights, there was a sector that was really against prior users' rights. Again, I felt like, well, if they had been practicing this invention in secret, the downside, I think, for the patent system is that you would have more trade secrets and maybe fewer patents filed, and then you something happens with the one who filed, and you didn't know anybody was practicing it. So it's an interesting issue there. The other thing for universities were who pays damages if you lose, who pays if you lose. And again, we ended up feeling, and this was, in the university, I think, ended up feeling, we would never file a lawsuit without a reasonable expectation that we were right. That the infringer was infringing. So we felt that in good faith, we would always file in good faith. And I know a lot of universities felt that this would prevent universities from suing infringers. It's a tough one, that one.
If I can just, one
Sure,
little quick
yeah.
comment. A lot of people have struggled with that dichotomy between good or appropriate NPEs and bad or poorly intentioned NPEs, and people can't craft terminology to actually distinguish the two adequately. So, be a good law school exam question.
And for those interested in this, there is a project going on here at Stanford Law School that's looking at kind of classifying different entity types involved in litigation, and not just like evil and good, but based on a wide variety of business models. And I believe we'll be having a conference at some point this spring as that database gets rolled out. I think we have time for one more question. In the back. So microphone coming, just one second.
Hi, so before there was a comment about how it's better not to have industry-specific rules. I wanted to ask, isn't that kind of the core of the issue here? Because a lot of the discussion today was about biotech and life science, but then the Alice decision was also directed towards business methods. So it looks like the Supreme Court's trying to apply a common metric across both high capital industries like biotech and life sciences and low capital industries like, say, software. But just adding on to that, isn't there already kind of two different standards in place? If you look at enablement, it's much stricter and higher for the life sciences than it is for, say, engineering or software.
So machinery are part of the predictable art, and so you don't need as much 112 support. And pharma and biotech tends to be the unpredictable arts, so you need a more robust type of disclosure. It's sort of the 101 issues, everyone still wants one size fits all. We don't want to favor or do different standards with different technologies because once again, we're creative. I could take something that's biotech and maybe try and push it more to a mechanical type way if I had to, right? You can be very creative or crazy with claim drafting. So people in general want 101 to be a one size fits all. But you're right, natural products versus abstract ideas, I mean, those are, people haven't even been able to define the two of them. So we're using words and terminology, and a lot of this, even when it comes to NPEs, it's eye of the beholder. So even if you try and capture a definition, Kathy could be coming at it from a totally different way, and I thought I captured precisely what she and I wanted to do in writing, and I didn't capture them. So in general, the consensus is we want a standard 101. Now, Dave Kapos, my predecessor at the PTO, he would like, if possible, the total elimination of 101. Or, if you keep 101, remove the judicial exceptions. Because people are looking at redrafting 101 to make it more fair or balanced, and apparently a number of organizations are trying to do it. I know what some of them do, but not all of them. And nobody's been able to come up with anything that they think is, no one's proud of their new statutory work product. So they really don't even feel comfortable sharing it yet, most people. This is all a work in progress, but at least people are looking at it and trying to do good change. And I look forward to your NPE report.
So any last 30-second concluding comments from our panelists?
Just thank you for being here, and I feel honored to have been able to speak.